Good afternoon, friends. Let us solve one question which was in the advocate on record examination. The question is, an advocate on record of the Supreme Court addressed a postcard to a party against whom notice was issued by Honorable Supreme Court of India. The question is whether the advocate on record is guilty of professional misconduct warranting disciplinary action against him. So we have to discuss with relevant case law. Firstly, friends, the answer is in the affirmative. Yes, an advocate on record of the Supreme Court who addresses a postcard directly to a party against whom notice has been issued by the court may be held guilty of professional misconduct, especially if the communication is intended to influence or interfere or threaten with the judicial process. Relevant judgment, as asked in the question, is PD Khanderkar versus Bar Council of Maharashtra, 1984, Volume 2, SCC 556. The facts of the judgment are, in this case, an advocate wrote letters, postcards directly to a party against whom proceedings were pending. The letters were considered to be an attempt to interfere with the administration of justice and intimidate the other party. So, Honorable Supreme Court held that such conduct amounts to professional misconduct. Writing directly to a party, particularly when the matter is sub judice, is highly improper and unprofessional. The advocate on record, being officer of the court, is expected to uphold the dignity of the legal profession and not resort to tactics that may prejudice or influence the judicial process. So the key observation in this judgment were, an advocate must not adopt tactics which are not only improper, but also designed to threaten the opposite party. Now, why it amounts to misconduct? Firstly, it is violation of professional etiquettes. An advocate, particularly an AOR, is expected to communicate only through proper legal channels. Writing directly to the opposite party is unethical unless legal necessity under the rules allows so. A postcard is an open form of communication and may be used to intimidate, shame, or coerce the party. This compromises the fairness and impartiality of the legal process. Furthermore, it is breach of Bar Council rules. Under Chapter 2 of Part 6, Bar Council of India rules, an advocate must maintain dignity and fairness in dealing with the opposite party. Now, applicability to advocate on call. An AOR of the Supreme Court holds a position of higher trust and responsibility. Misuse of that status for any purpose, even though seemingly minor actions like a postcard, can attract disciplinary action. So let us conclude this question. So saying yes, the AOR is guilty of professional misconduct, writing a postcard to a party against whom proceedings are pending, especially from someone in the capacity of an advocate on record. It violates the ethical and professional standards of legal practice. The judgment in PD Khandekar versus Bar Council of Maharashtra is a clear precedent that such behavior warrants disciplinary action under the Advocate Act 1961 and also Bar Council of India rules. That's all, friends. I will be again with more videos. Be attentive, be connected. That's all. God bless you all.